Hi everyone, welcome back to my YouTube channel. This is Raz, and in this video, we will talk about basic succession. So if you're ready, let's start. So our Civil Code of the Philippines provides that the right to succession is effected from the moment of the decedent's death. So we have been discussing from our previous two videos about transfer of property, whether during the lifetime of the donor or upon his death, and this transfer could be subject to either donor's tax or estate tax. So our discussion is focused on the transfer of property upon his death. So the Civil Code, our law, provides that succession or the right to succeed to claim ownership of the property of a deceased person is effected from the moment of his death. It is also said that the transfer of properties left by the deceased accrues at the time of death. Consequently, the determination of the tax on a property is traced back to the moment of his death. So, since the effectivity of transfer accrues upon the death of the donor, then as a consequence, the estate tax, also accrues or is determined back to the moment of the death of the person. In summary, the time or point when the right to succeed arises is also the same time when the estate tax is computed. So in this video, we will focus our discussion on the succession process or how to compute or who will succeed the properties, the estate of the decedent. Succession is defined as a mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of inheritance of a person are transmitted through his death to another or others by will or by operation of the law. So in this definition, there is a lot of, as you can see, highlighted words, phrases, which actually the salient feature of the word succession. So number one, succession is a mode of acquisition. So it is a mode of acquisition because a person or anyone can acquire properties in many ways. So for example, if you buy something, then that is a mode of acquisition. Or if you exchange something for another thing, then that could also be a mode where you could acquire properties. But succession is also another mode wherein someone will step up, will claim ownership of properties from someone who just died. Okay, so that's basically the concept of succession. So by virtue of this succession, the property, either personal or real property, the rights, if there are rights, like franchise, and obligations to the extent of the value of inheritance. So when we say in succession, it is not only the properties and the rights or the wealth being transmitted, but also the obligations, the remaining unpaid obligations of the deceased. The amount or the extent of the obligations that you could acquire or inherit from that deceased person is also limited to the extent of the value of inheritance. So, as a successor, you could not inherit an obligation or an unpaid obligation which is more than the property or rights or assets of the person who left behind those obligations. Okay? And these property, rights, and obligations pertain to a person. Okay? That is the deceased person. Okay, so transmitted through his death. So it is through his death that you could acquire this property, rights, and obligations to another or others either by will or by operation of the law. So there are two ways, basically, that's through will or through operation of the law. In our other videos, we will discuss about testamentary and intestate succession, which focus on discussing the will and operation of the law. Okay? But in this video, our focus is the concept of succession. So the basis of succession, why there is a succession. First basis is family relations. It assumes that the principle of natural law necessitates a person to provide for those he would leave behind. So, if you are that someone who is the head of the family or a father or a parent and you have children, or if you have someone depending on you, then whatever wealth you have accumulated during your lifetime, this wealth could be transmitted to your, of course, family, those people you left behind. So the dissident's wealth acquired during his lifetime is presumed intended for the benefit of his loved ones. So that's under family relations because, of course, who else would inherit the properties or the wealth? Of course, that would be your family. Another basis of succession is the implicit ownership. As a consequence of death, the heirs assumed ownership of the property left by the decedent because they have the primary rights over the inheritance. So, among other persons, among other people who would have claimed this over these properties, of course, the family or the heirs have the legal rights to claim ownership over those wealth that the person who just died accumulated during his lifetime. Okay, so these heirs, these successors have the primary rights over the inheritance. Not their neighbors or their friends, but the heirs, the children, the parents, the wife, the spouse. Okay, that's under implicit ownership. And the third basis is the socio-economic. So the wealth left behind by the decedent should be actively used to provide economic benefit to the community. So when someone dies and then he left behind properties, especially real properties, farmland, and assuming there will be no one to inherit these properties will become idle. Well, there must be someone who would inherit, who would own this property to keep them actively moving, providing benefits to the society and the economy as a whole. We now proceed to the elements of succession. There are actually three elements of succession. Number one, the decedent. This is the person whose property is transmitted through succession, whether testamentary, intestate, or mixed. So when I say decedent, this is the person who dies, and then this is the person whose properties, rights, and obligations are transmitted through succession. And the succession process could be testamentary, when there is a will, or intestate, when there is no will or when the will is void, or mixed, meaning partially testamentary and partially intestate. So, another element is the estate. The estate refers to all property, rights, and obligations of a person, that's the decedent, which are not extinguished upon his death. So, the estate refers to all properties, whether real or personal properties, rights, and of course, obligations. These obligations are the unpaid obligations which are not yet extinguished upon his death. And number three, or the third element, are the successors and the heirs. These are the person or persons called to the succession to succeed the estate of the decedent, either by the provision of a will or by operation of a law. So these are the persons who will inherit the estate. So those are the three elements of succession: the decedent, the estate, and the successors and the heirs. Okay, so let's discuss these elements individually. So number one, you have the decedent. So a decedent is the person who died and whose property is transmitted through succession. He could be a testator. So when someone dies and he has a written will, meaning he left a will, then he is called a testator. He is a decedent whose properties are to be transferred through a written will. And a transfer of property from a decedent without a will is called intestate succession. So when there is a will, the person who died is called a testator. And then when there is no will, it is called an intestate succession, meaning the law will apply as to how much would an heir receive. And number two, the second element, estate. An estate refers to the properties, the property rights, and the obligations to the extent of the value of inheritance. So again, as I've said, when I say estate, these are not just properties or property rights. It also include obligations, liabilities. These are unpaid liabilities or obligations of the decedent, which remains unpaid at the time of his death, meaning these obligations are also transmitted to the successors, however, only to the extent of the value of inheritance. If the obligation or the value of obligation or liability is more than the properties or property rights combined, then the successors could not or should not be burdened of those excess obligations after exhausting all the estate, all the properties and property rights. Okay? So it means to say that the successors or heirs could only inherit the property or property rights after deducting the obligations. Okay? These are the inheritance to be transmitted to the successors. So let's have the third element, that is the successors or heirs. So a successor is the heir or the person to whom the estate is to be transferred. So they are the person or persons who will inherit the property or the estate. Successors have the legal rights to receive the estate. So they have the right to receive, but they cannot be compelled to receive. Okay, so if I am one of the successor of a decedent of someone, and I have the legal right to claim to receive the estate, but I could refuse if I don't want to, because the right to receive doesn't equate to actually receiving it. Okay? I could not be compelled to receive the estate if I don't want to, but I have the legal right to receive. Okay? Successors could be classified as primary compulsory heirs and secondary compulsory heirs. So let's discuss this to classification of successors. Primary compulsory heirs, these are the successors to whom the legal portion, that's called legitim, of the estate is first received by the law. So the primary compulsory heirs are the very first persons or people who will be called upon to receive the estate. And then if there is a will, there is this portion of the estate called the legitim, which is reserved for them. This legitim or portion, which is restricted for them, could not be disposed by the decedent to anyone other than the primary compulsory heirs. Okay? So meaning to say, among the total properties, the rights, the estate of the decedent, there is this portion which is restricted for disposal. This portion, this legitim, is exclusively for the primary compulsory heirs. So the first or the legitimate children and their legitimate descendants. So the very first persons to succeed the estate of the decedent would be the children. Okay, because they are the second generation who would inherit the parents. If the deceased is a parent, then the children has the legal right to claim over those properties, and if they are not present, assuming they're dead, then their legitimate descendants, the grandchildren of the deceased, or and so on. So this is a direct lineal descendants. Okay, again, the children would be the first, and if they are not present, if the children are already dead, so their descendants, their children. Next, we have the surviving legitimate spouse. So when we say surviving legitimate spouse, this means to say that the spouse is actually married to that person, legally married to the deceased person. And of course, the third primary compulsory heir is the illegitimate children and their descendants. When I say illegitimate children, these are the children who is born either before the actual marriage, the natural children, or those who are born outside marriage. So if the deceased person has children outside of the current marriage, then those children are illegitimate children. They can also, of course, inherit, but their inheritance is half lesser than each of the legitimate child. Okay? So, an illegitimate child shares only one half of the share of a legitimate child since they are born outside of marriage. So if one legitimate child inherits 2 million, then an illegitimate child would only share 1 million. That's one half of the 2 million. So these primary compulsory heirs will be the first persons to inherit the property, and in their absence, because maybe they are dead or they're just simply not present. So the next to succeed will be the secondary compulsory heirs. So these are the successors to receive the estate in the absence of the primary compulsory heirs. Number one, we have the legitimate parents and their legitimate ascendants. So if the person who dies is a child or a son or a daughter which is unmarried, no children, then of course there will be no primary compulsory heir. Then naturally, the parents would inherit the estate of the deceased. But these legitimate parents and ascendants only inherit in default of the legitimate children and their descendants. So in succession, the first to be called will be the children. If there is no child, then their descendants, if there is any descendant. If there is no descendant, then the parents. Okay? If the child or descendant is present, then the parents will be excluded from succession. For example, if the deceased person is a father of an only son, okay, so for example, A is a father and B is the son and C is the grandson. And then A died, so naturally we'll call on B, who is the son. But if B is also dead before A, then we will call C, the grandson. So if the grandson is present, all the parents of the deceased of A will be excluded from succession. But if the child is dead or is not present and the descendant is also not present, then we will now call on the parents to inherit the estate of the deceased. Okay? And next will be the illegitimate parents. There will be no other descendants. So they only inherit in default of the surviving legitimate spouse and illegitimate children and their descendants. So again, if there is no other descendants and there is no surviving spouse and no illegitimate child, then the illegitimate parents could come in to succeed. In the absence of the primary and secondary compulsory heirs, the decedent's relatives up to fifth degree of consanguinity shall inherit the estate. So in our other video, we'll discuss the degree of consanguinity. But to give you an idea of what is a degree of consanguinity, if there is no other relative within the fifth degree of consanguinity, then the government shall inherit the whole estate under escheat proceeding. So if there is no other relative within fifth degree of consanguinity, then the government will inherit the entire estate. So that is actually sad if you don't have any relative. Okay? If there is a will, the decedent may name other persons to inherit the free portion of the distributable estate. So, as I have said a while ago, we have this portion reserved for the primary compulsory heirs because they will be the first to inherit this portion. That's it. That is the legitimate, the restricted portion. But if there is an excess portion, that is the free portion, this free portion may be distributed to anyone. The decedent may name other persons, even if not relative, to inherit this free portion. Okay? So to give us a summary of our discussion, we have this. So we have this, the decedent, and the first to inherit will be the legitimate children and their descendants. And in their absence, if there is no child and there is no descendant, the legitimate parents and their ascendants could come in. If there's a parent, the parent will inherit. If there is no parent, then their ascendants. And aside from that, concurrently, the spouse will inherit together with a child and the illegitimate children and their descendants. So, in the absence of these two, and there is no other descendants, there is no child, no descendants, no surviving spouse, no illegitimate children, no descendants, so the illegitimate parents will come in, okay? Assuming there is no legitimate parents, of course. So if these five people is absent, the next you call on will be the relatives up to fifth degree of consanguinity. And then if there is none, then the government shall inherit the entire estate. Okay? So this box here, they are the primary compulsory heirs, and these are the secondary compulsory heirs. Brothers and sisters of the decedent are not compulsory heirs. So they don't succeed. They are not called on succession. They are not part of the succession process. Brothers and sisters could only succeed if the primary and secondary compulsory heirs are absent. Okay? So, however, it is not against the law if they will be given inheritance as long as the legitimate of the compulsory heirs is not impaired. So, as I have said, if there is a free portion, then the decedent could distribute this free portion to anyone, including the brothers or his brothers and sisters. But naturally, legally speaking, brothers and sisters of the deceased person is not a compulsory heirs and will not be called upon to succeed the inheritance. Okay? If you have questions, please comment them down. And then if you're new to this channel, please subscribe, click the bell so you'll be notified whenever I will upload new videos. Thank you so much and bye!